Got a black picture there. Not sure why there's a black picture on my YouTube. Camera's going. Right, there we go. All right, Doug, we all set?
You're on the record, Your Honor.
All right. Good afternoon, everyone. My name is Chuck McLean. I'm the Chief Public Utility Law Judge at the Maryland Public Service Commission. We're here for a status conference in case number 9408, which is in the matter of the application of Perennial Solar LLC for a certificate of public convenience and necessity to construct an 8-megawatt solar photovoltaic generating facility in Washington County, Maryland. Thanks, everyone who's here today, just so we can make sure get an accurate count here. If we could go through and if you could state your name and who you're representing, please, for the record. We can start with Ms. Elephant.
Good afternoon, Judge McLean, Carolyn Elephant for the applicant, Perennial Solar LLC.
Good afternoon, ma'am. Mr. Dean.
Michael Dean on behalf of the staff of the Maryland Public Service Commission.
Thank you, sir. Miss McLemore.
Sandra McLemore on behalf of the Power Plant Research Program. Also today, Miranda Brown is here to answer any questions. She's a consultant.
Okay.
PPRPs.
All right, thank you. Looks like Mr. Cleaver.
Yes, Your Honor. Good afternoon. Joseph Cleaver on behalf of the Maryland Office of People's Counsel.
Good afternoon, sir. And it looks like Mr. Bright, are you there, sir?
Yes, I am, Your Honor, along with Kirk Downey, both of us representing the Board of County Commissioners, Washington County.
Good morning, gentlemen. Or good morning. Good afternoon, I should say. I'm sorry.
Good afternoon.
Time down here in the basement. I can't see the sun. All right. And then it looks like we've got Miss, if I Fury.
Sorry.
I'm
And
sorry.
I am the spokesperson for No Solar Farm.
I'm sorry, ma'am. Could you say that again? You're kind of breaking up a little bit.
I am in charge of the residential group,
Okay.
supposedly.
Understood. Okay. All right. Thank you, ma'am. I appreciate it. Appreciate you being here. All right. I called this conference because to say I'm frustrated is an understatement. The way the procedural schedule went, there was supposed to be a status update that was filed on May 8th. Nothing was filed. On May 11th, I asked the applicant what was going on, if they could provide a status. Again, nothing was provided. On May 14th, I was told that the applicant would be filing something that day. Nothing happened. May 20th, again, no update was filed. Ms. Elephant, what's going on with this case?
Well, first of all, Your Honor, I truly do apologize. I think there's been some confusion in the case. Obviously not after all of Your Honor's orders, but at least initially, when the case was put on a hold due to COVID back on April 8th, it was our understanding that the case was completely, that it was in suspension, though I know Your Honor did ask about a status report. After Your Honor had issued that order, I reached out to the other parties, and then there was a little bit of confusion about what kind of information the applicant was supposed to provide. There was a PPRP did file a certificate of completeness of the application and began its review. And when the application went into abeyance, we were under the assumption that everything was frozen in time and that the PPRP review wasn't continuing at that point.
When was the PPRP completeness determination filed?
The completeness determination was filed November 4th, 2019, mail log number 227369. The PPRP, I believe, and I will let Ms. McLemore speak for her client, but it's my belief that at some time at that point, PPRP began reviewing the application. We submitted some more responses to DRs, and then there are just a few outstanding DRs, DR4 and DR5, which my client has also, as again, when the case went into abeyance, and I do apologize on behalf of my client if this was a misunderstanding, we had thought that when the case went into abeyance and the public hearing was postponed, that everything was on hold. And that was something that was also important, that was something that also impacted my clients, because as a result of COVID, they have been reprioritizing their work to focus on live projects. They're owned by Community Solar, which is a solar development company, which has tried to avoid any solar layoffs, which have been pervasive in the industry. So they've been reprioritizing. If they had thought that this project was moving forward instead of being on hold because of COVID, they would have devoted more resources to it. So I'm just explaining the context that has contributed to some of this confusion here.
Okay.
But anyway, most recently I've spoken extensively with Ms. McLemore, and my client has also, the applicant's project manager, Mr. Anderson, has been in touch with some of PPRP staff to try to figure out what to do in terms of providing some of this last information, which PPRP has said that it needed. And again, we were driving towards a belief PPRP's ERD was due after the public hearing. And so when the public hearing was put into abeyance, that seemed to us like a stopping point. And so I do apologize for not submitting a status report. I am very cognizant of all of the interveners who are participating in the case. I didn't want to provide partial information and then change it, which also causes confusion. But I do respect Your Honor status reports, and we do want to get the case back on track. I understand your frustration, and again, I'm very sorry. It's just, there have just been a lot of these moving parts, but it seems like we're very close with the application.
Right. Well, I get the confusion, but I mean, when you say something, you're going to file something, just whether it's complete or if something changes, and file it. I mean, or say, there's nothing to report at this time. I mean, but when I ask for something, well, when nothing's filed, that's a concern. And then when I have to repeatedly ask for something and you tell me it's going to be provided and nothing's provided, that's a concern. Ms. McLemore, does PPRP have everything it needs to move forward with a review of this project?
No, Your Honor. There's responses to DR 4 and 5. We have to have, at March 26th, I sent an email to all parties, including the judge, on this case, and it indicated that once we received that information, we would need 8 weeks in order to complete our complete and independent evaluation. We did file a completeness review at the beginning, but that's initially what needs to be included in the actual application. In order for us to continue to finalize everything, we need this information. It's regarding glare, it's regarding another couple of things. I do have Ms. Brown on the call today if you need to ask her specifics about that information, but that is what we need in order to finalize. Once we get that information, it will take us 8 weeks.
Okay, yeah, I do recall that email. I do recall the 8 weeks. I think that was, maybe I thought that and I realized that you had filed a completeness determination, but was that maybe premature? Is it still complete? Is it still not complete if you're missing things?
In that completeness, and I don't have it before me, it's a little hard to look while I'm on the computer.
It's okay.
But I believe in that email, when I filed that, when I said it's complete, it was with the understanding that we would get the information we had requested. DR5 was a follow-up to DR4. We still need that information. This is kind of a chicken and egg thing, because when you file a completeness review, it stops everything at the beginning of something. We don't like to try to be nitpicky on the completeness review because we don't want to stop everything and we assume we can get things in discovery. This is not something that's new. It's not anything unique. It's just information that we typically get in order to finalize our independent evaluation. At the beginning of a document, sometimes they don't have all the information as well at the beginning of the CPCN process. So some of that information kind of is ongoing. And so that's another reason. But if you do have questions about the details of that information, you can give Ms. Miranda. Okay.
I'm just trying to figure out what, I don't need specifics. I'm just trying to get this case moving forward. Ms. Elephant, do you know what's outstanding and when can you provide it to PPRP?
So There's some information. We filed the solar glare analysis on February 19th, 2020, and there were a few follow-up questions on that. We have been getting some conflicting information, and again, I can't say exact. This is from discussions with my client and from PPRP. Information about the extent of information that's required on some of these, both solar glare analysis and also the placement of panels, the height of the panels. And the reason for that is because some of these things are subject to change with the passage of time. The applicant may employ a different set of panels. And rather than be unresponsive and just say, this is something we're going to provide later, I know that my client, Mr. Anderson, did reach out to PRP, though not Ms. Brown, and maybe we're dealing with the wrong person, and we should be dealing directly with Ms. Brown. We've been dealing with PPRP staff, I guess internal staff rather than consultant. I don't know what the status of that is. They are trying to work together. We've had a good working relationship in the past.
Okay, so you don't know. Go ahead, Ms. McLemore.
Can I respond to that? I'm sorry. No, Ms. Brown is not the person you need to be discussing it with. It is Mr. Seaman. However, based on my understanding, they have not had a conversation for 6 weeks. We need to get that information. That has been consistently what we have said from the beginning, and we will work in any way we can with the applicant to obtain that information. Whenever they can provide it to us, whenever the judge would like that to happen, all we need is 8 weeks once we receive that information, and we're fine to file. So I just to make that clear.
Gotcha. Now, Ms. Elvon, do you have any estimation as to when the outstanding information can be provided?
It should not be difficult to provide it. One of the things that had happened in the past was that, again, PPRP's report, PPRP did say it needed 8 weeks, and we knew that there was going to be a public hearing before PPRP put the ERD together. So we were gathering that information. The public hearing internally for my client is something that they internally work towards. So when that was something that was put on hold, it made it shifted the priorities because it was difficult to justify internally getting these responses. My understanding is that this is something that can be provided quickly. I can try to get the information from my client. I believe he is he's not showed up on the call, but I think he just perhaps called in.
Yeah, Judge, apologies. This is Tom Anderson. I am on the call. You had just started it on everything, so I didn't want to interrupt you. But I would like to say that Ms. Elefant has characterized the community energy side of this, I think, fairly well. Our view was, as she stated, when this went into abeyance, that it was essentially shifting everything forward, and I was instructed to reprioritize and refocus. And had I known that we were, expected to keep this thing moving technically forward, I likely could have persuaded management to allow me to get some resources internally to finalize some of these answers. Since all of this did start bubbling up, I did have a brief email back and forth with Mr. Seaman. He acknowledged having received the previous glare study and emailed back that he would let me know what he heard back on that after the glare analysis. The other few technical responses that are out there, hearing this discussion, I do believe I can get the information PPRP is looking for relatively quickly to wrap that up.
But when you say relatively quickly, I'm sorry, Mr. Anderson, go ahead.
Yeah, within the week.
Within the week.
Yes, but again, this is an odd time, and I get my priorities internally, and we did. I guess we did perhaps misconstrue what everybody was thinking when the project went into abeyance for this crazy time. So we do apologize as well.
All right. So
Yeah, but we do believe the application is as complete as others we've had in, and that this fact finding that PPRP is going through is routine. We've been through it before. So we can put the time into it here in the next week to get these final responses in.
Excellent. Okay. All right. With that, if PPRP can get their stuff within the week, I don't see any reason why we shouldn't be moving forward trying to get a public hearing. I know these times are not ideal, but we've been relatively successful, I'd say, in holding hearings, both public hearings, evidentiary hearings. The commission holds weekly admin hearings. So I think we can move forward if we need to, doing a hearing virtually.
Your Honor, if I may speak to that, and I defer to Your Honor's experience in holding these hearings virtually. I don't mean to suggest that they're not effective. Because this project has been the subject of so much scrutiny, it's gone up and down to the Court of Appeal. We do have some concerns about possible legal challenges to the use of a virtual public hearing, just because of the requirements of the statute. And again, that may not be an issue. I certainly defer to Your Honor and to the Commission's expertise on this, but we have some concerns. And also, Your Honor has been present at other public hearings with my client. He does like the opportunity to meet people face to face, to be able to show the diagrams of the project, and
Sure.
maybe something that's lost on that as well. So I just wanted to voice those points to preserve them.
Well, in terms of legally, I think we're okay on that. Now, I mean, of course, there's many layers above me that may disagree, but I will note that I just did a public hearing for a pretty controversial wind farm out in Western Maryland the other night. We had 40 plus participants, went on for 3 hours or so. And that one has been before the commission 2 or 3 times. It's called Dan's Mountain. If you're having trouble sleeping tonight, you can go on our YouTube channel and watch it. And there are ways to kind of share a screen. So if Mr. Anderson or whoever was making a presentation, you can put it up and share a screen for folks to actually see the project. They can walk people through it. I just want to get this case moving, and I think we have the ability, although not ideal, we have the ability to have these public hearings, and hopefully we'll be able to have a public hearing live sometime, maybe in the fall, hopefully when all this is gone away and we're back to some kind of semblance of normality.
Your Honor, Tom here again. I want to interject quickly, if I may. And I chuckle a little bit. That was our lawyer covering our legal basis very well.
No, it's fine. No, I get it.
And we appreciate that. I have this slightly different concern, and I'm glad Mrs. Fiery's on the call. My main concern is in addition to, and being clear, I like the idea of having that personal face-to-face interaction. I think it fosters dialogue and allows us, if there's any chance to resolve differences, that's the best way to do it. But in parallel with that, and of equal importance to community energy, is that the stakeholders who do have concerns or are just opposed don't feel disenfranchised by the technology approach. And so with that, I mean, we would really defer to that neighbor group on our side. We just see it as being complicated and don't want to be pushing something that folks are uncomfortable with. So
Understood.
Thank you.
I appreciate that. Ms. Fury, are you still there?
Yeah, I'm here.
Oh. Do you have any concerns about participating in a hearing kind of like this, ma'am?
One concern, one of the conditions that came out of the appeal was that the public hearings have to take place in the county in which the project is proposed for.
Absolutely. Well, so you would want to just, if I'm understanding you correct, you'd want a live hearing.
We would prefer that, yes.
All right.
Your
Any
Honor, one thing we could,
Go ahead, Ms.
yeah, I'm
McLemore.
sorry, Senator McLemore. What we could do in this case also, I think this is a slightly different schedule than we had in other cases in which we had the public hearing before we filed our initial testimony. Perhaps we could go ahead and file our initial testimony and then wait until after that to schedule the public hearing. And that might give us more time so that it could be public. I don't know, but just a thought.
We could do it that way. Mr. Bright, Mr. Downey, does the county have a view on this, sir or gentlemen?
Well, as you know, the commissioners had sent a letter asking that they be able to sit with you when you conducted the hearing. I assume they would have the same opportunity, although it would be virtual participation as we're doing.
Yes, sir.
I have not asked them specifically whether they'd like to prefer to go forward in a virtual manner. I am guessing their preference would be that we would have been able to have it in the customary live fashion. But we certainly realize that these times require accommodations for everyone's health.
Yeah, that's obviously my preference too. I just don't know how far to kick it down the road. I like Ms. McLemore's suggestion of allowing PPRP to file their testimony and then have a hearing, with the understanding that we still may have a second hearing afterwards. And again, it's not typical, but if we could do that and then have a live hearing after at some point down the road, I think is probably the best way to go, at least to keep this case moving forward. Because right now it's just stagnant. And what's that?
I'm sorry to interrupt you. This is Judy.
Okay,
A lot of my people are older residents, and they can send an email. I don't know if they would know how to connect to something like this.
Okay. All right. Well, there's a couple different ways. Again, we had the very similar issue out in Allegheny County, ma'am. There's options to call in. There's options to log on through your laptop or a smartphone. So there's a few different ways that people can log in, ma'am. And it's not, the technology is not overwhelming. I can promise you that.
Well, I agree with you, but I'm talking about people in their 80s.
Yes, ma'am. Yes, ma'am. Understand. All right. Anyone else want to weigh in? All right. Why don't we do this? Miss Elephant and Mr. Anderson, you'll get Miss McLemore the outstanding information within the week, which is, we'll say June 5th. And if you could also start thinking about a procedural schedule, and I'm fine to do it along the lines of what Ms. McLemore had suggested, having it after the other parties, PPRP staff in the county, file their testimony in hopes that we can have it live. If we can't, we'll go with a virtual hearing and we'll try and have a live hearing or somewhere down the road. Okay?
Okay, I think we can agree with Ms. McLemore's suggestion. I'll speak with her after the call about scheduling and well, I guess we'll need input. I don't know if we need input from the other parties on that proposal.
Yeah, I would go ahead, Ms. McLemore. Ms. McLemore?
I'm sorry. It's hard to figure out who's talking next. Would you be opposed to, sometimes a while back, it used to be that the public hearing was right before the evidentiary hearing. In this case, I don't think we should do it right immediately before, but perhaps we could even scoot it as far back as we think is feasible amongst the parties as we do the proposed schedule for you. Would you be opposed to that kind of idea?
I'm not opposed to anything that's going to get this case moving forward. All right. And again, I want to hold out the hope that we can have these hearings live to make it easier on the residents. But again, if we need to, we'll do it virtually and with with the idea that we'll do another, we'll still have 2 hearings, but at least hopefully one of them will be live. Okay. Yeah, and Ms. Alafant, I would recommend touching base with all the parties before you submit anything in terms of a schedule. Okay?
Okay, I will do that.
All right, thank you, ma'am. Anything else before we conclude this hearing? All right, thank you. Mr. Bright, you have anything?
No, I think we're fine. Thank you.
Yeah.
It looked like you were conferring there, so I didn't want to shut you off. All right. Well, thank you all very much. Enjoy the rest of your day, and hopefully we'll see a schedule here in the next week or so. All right.
Yeah.
We're off the record.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you.